Hello friends, based on the feedback from my last video, today we are specifically going to discuss timelines and process costs. Uh, Besides discussing these two topics specifically, I will also try to speak in Hindi because some of you have asked me to explain to you in Hindi as well. So anyway, let's start. Uh, So this is what your pre-pack calendar should look like. So what we see here is that the pre-pack process is in three phases. Phase one, where the corporate data or the MSME is going to make a lot of internal discussions, decisions, whether they want to go ahead with the pre-pack process, whether it's going to be beneficial for them, what are the pros and cons specific to their requirement. And then they have to mentally prepare themselves for a lot of things because once the MSME initiates a pre-pack process, then it's going to be very difficult for them to, or rather impossible for them to withdraw. And unless the COC decides to terminate it, or there can be so many other, areas which this process can go into, starting from resolution to even liquidation, to take a vesting of management by the resolution professional. So all these options have to be discussed and decided upon. So according to me, almost 3 to 4 months are going to be utilized by the corporate data to take a call. So let's go over it. Assuming that that on the 1st of January 2021 is when the MSME sort of chooses to explore the possibility of a pre-pack. Then on the 1st of January, they should discuss the pros and cons of the process specifically to them. And this discussion, if continues for a week, then by the 8th of January, we should look at the communication of such pros and cons of the process to the directors, the owners, and any other relevant stakeholder as to what the conclusion of this internal brainstorming has been. Once we communicate the pros and cons with the other owners, which may then take another week, then by 15th, we should look at voting to be done by the directors and the members, and they should have a formal vote of some kind of a voting process which says, all right, if and this is something which is internal to them, they can choose to decide that if majority 51% decides to go ahead, then we will go ahead and start exploring the process further, or any other percentage of voting that they might decide upon, which let's assume will take another week. Then by the 22nd, we should start looking at the eligibility of MSME as a PPIRP initiator. So here I'd like to say that the MSME has to have, there is a set of eligibility criteria for the MSME. And so if we look at the checklist of regarding the eligibility criteria for MSME, then the way we see it, we go to checklist, MSME data eligibility of PPIRP. So if we were to look at this, what we find is, let me quickly bring this back. So this is the checklist we're looking. So they have to figure out whether they are actually classified as MSME as per the MSME Act, and whether they have a certificate or not. Then who the corporate applicant is going to be, and a corporate applicant could be the corporate data or a member partner or an individual who's in charge of managing. So who the corporate applicant would be is something that they'll have to look into. Ensure that there is a default as per section 405 BC. So default of 10 lakhs is required, and whether it's there or not. And then the whole list of other general checklist, whether the MSME has not undergone PPIRP in the previous 3 years, meaning the pre-pack process can only be revisited after 3 years. If you have already undergone a pre-pack process, then you'll have to wait for another 3 years before you can initiate a pre-pack, or that you are not undergoing a CIRP, or that you're not undergoing a liquidation or have not been liquidated, and whether you are eligible under 29A. Since the objective of the MSME predominantly for undergoing a pre-pack process is to take back the corporate data, then it is best to verify your eligibility upfront, because once you initiate this process, it will get more and more expensive, and then you would have expended so much of time and energy. So it's best to ensure all the checklists, and so that you're not stumped somewhere further down the lane, down the time, and realize something that you should have contemplated previously. So ensuring that who the resolution applicant is going to be and whether they are eligible under 29A. It's always a good idea to check 29A eligibility verification at this stage. The other checklists are not really vital, because this is where financial creditors will come into. This actually goes into phase 2, where we go to the financial creditors for a 10% approval for resolution professional, or 66% approval for the proposal. Then there are a bunch of declarations which are very important, and you have to make sure that are you prepared to make those declarations. So the declaration is that we do have the inclination and the wherewithal to undergo the process, meaning that we have set aside a budget which is expected, which is the pre-pack expense expected to be spent, that you are not so other than these declarations, we can see not to defraud anybody. So these are general declarations, and yes, since we have already taken an internal vote that passing a special resolution would not be an issue, and so there are these bunch of declarations, and so you have to check whether the MSME is actually eligible to undergo the pre-pack process. Coming back, so by the end of the first month, we would have reached the eligibility. Then by the 31st, we will then have another first round of informal discussions with the financial creditors. That look, we are planning to start. We have internally discussed. We know what we are getting into. So once we initiate, whether you are broadly open to it, and if yes, then we will get back to you with a preliminary information. We'll start preparing the information memorandum or the resolution plan. So it's always better to start involving the financial creditors in the first month itself. Then if the creditors also sort of so broadly, we are generally doing we're testing the waters as to how the whole pre-pack process is going, and whether the financial creditors are on board or not. So assuming everything is in place, we have had an internal discussion. We have done a broad checklists on broadly that we are eligible, and that even the resolution applicant, whosoever that may be, it could be the promoter or somebody else, an investor along with the promoter, and that the eligibility also is there, and we have spoken with the financial creditors. Then we take another 15 days to do some basic asset valuation and forensic audit. Now this is something which, none of these things that you see in the blue are really mentioned in the law. These are just informal processes. They have been let free. The MSMEs, corporate debtors, are free to manage this informal process. So what you see in the blue is a very tentative way of how the process is going to run. And although law never does not talk about asset valuation or forensic audit, at this stage. But I personally feel that it is very critical for both of them to be done. Reason is that without valuation, whatever you put on your base resolution plan and show it to the financial creditors, they would want to know the basis on which you have reached certain conclusions. So, and if they see an asset valuation report based on which you have made your plan, they would be more willing, more convinced to take it further. Otherwise, they just might reject the plan and may not even initiate the process. Or there can be so many things that can go wrong later on. Although valuation will be done by the resolution professional somewhere down the line, but that is only if we go through we go past that stage. I'll come back to asset valuation again further down. Forensic audit is also very important because you have to give a declaration that there is no transactions that you've had in the past 2 years which will come under avoidance transactions, and that your books are clean. Now, if you were to say that, and later on, if it were to be found to be untrue, you could be hauled up. There are some the punishing provisions for having lied, for having initiated the process and giving wrong declaration. So, forensic audit is also something that you should do, and basis which you will state the declaration that you would be giving. Then you will spend another 15 days to make your preliminary information memorandum. So there's a whole list of things that you need to do for information memorandum. We will go over it. But broadly speaking, having prepared the preliminary information memorandum, I presume that we take another, it really could be 15 days or could be 1 month to make your base resolution plan. And and between the information memorandum and the base resolution plan, there may be 1 or 2 more meetings with the financial creditors, because our endeavor would be to make a base resolution plan in such a way that the financial creditors may not want to ask for auction process or Swiss challenge process to take place. So if there is a possibility of how we can avoid and best convince the financial creditors to not go through the remaining process. So we can actually even go to the extent of giving a base resolution plan in such a way that the financial creditors may be willing to do an OTS at this stage, and if they just might want to settle it out because they know that you are coming with the right intention for resolving the process. You have gone through the pain of identifying what the problems are, what potential solutions are, and how this resolution will actually go a long way in giving the financial creditors their monies. So base resolution plan, and then I assume that you will at this stage also will have to go through the form 1, which has tons of annexures. It's always better to be prepared with form 1 annexures and checklist, because this is something again which is going to happen sometime in the second or the third phase, the second phase. So in the second phase, on the last this thing, that when you have to initiate the PPIRP process, the RP will initiate the process on form 1, and which needs to be done here, because we don't want annexures to be found wanting at a later stage, because then by that time you would have spent a lot more money, because you have to understand that all this process, the cost of this process has to be borne by you. So we don't want to bear a cost only to find at a later stage something that you couldn't fulfill, because of which you'll not be able to initiate the process or take it through. So my recommendation would be to go through the Form 1 over here as well. So this is the first informal phase where you are generally discussing, just like we discuss within a family, for anything, and there's just an internal discussions. Then once you are ready with all these documents, will you go into phase 2, which is shown here in yellow. So the way I see it is that this could be a full 1 year process. Of course, we can bring it down to make it a 9-month process instead of a 12-month process. But very difficult. But here I have given some flexible, timeline that you see here. And so let's go with the assumption that it's a 12-month process. Now, having said that, we are now then going to actually have a declaration and special resolution made, and then with all these documents, as well as declaration, resolution, we will call upon the unrelated financial creditors and convene a meeting to actually get them to start the process. Now, please understand that that a lot of meetings would have taken place in the first phase itself, and so from here on, everything should be smooth sailing, because most of the hard work has been done during the first 4 months. Then within 15 days, by the 14th, okay, something is missing here. By the 14th, we will have the unrelated financial creditors to give their so maybe till 14th we are talking again. We are so by the 30th, let's jump here. So within 60 days, T plus 60. So what you see here, for example, T 15 days, it says T0 plus 45, meaning T0 is the first phase, or the first phase, the first 4 months. And this says T0 is so this is T0, this is, for example, T1, and this is T2. So this says, for example, T2 plus 30 means the third phase, the 30th day. So by the coming back here in June, that T1 plus 60, we will have the approvals of the financial creditors to file for application. Meaning that the unrelated financial creditors would give us a 66% approval in writing. Then within next 10 days, we are looking at approval of financial creditor for filing the PPRP application, appointment of RP. So this is an approval for financial creditors for filing an application. This is the filing of application and appointment of RP. Within next, by the 75th day of the second phase, we are looking at the RP, or rather the IP, to begin preparing reports and other documents. So what is going to happen is, here the process initiates. By the 10th, we have the insolvency professional on board, and then the insolvency professional begins to prepare his reports. Now, these reports and documents are very critical. The insolvency professional will ensure the information memorandum is right, the base resolution plan is as per law, the eligibility criteria of the MSME is eligible to initiate the process, and even the resolution applicant is 29A verified to be able to put in his resolution plan. And then by the 79th day, we're looking at in case there are class of creditors, then the communication for authorized representative has to be done by the insolvency professional. And then by the 90th day, the corporate debtor would have filed for initiation of pre-pack with the adjudicating authority. And although it is said that the adjudicating authority will decide within 14 days, but let's as I said, we just this is all tentative guidelines, so let's say that the adjudicating authority even if they end up taking 1 month, we have, so by the 29th, they will be deciding. By the 120th day, they will decide the initiation. Now, the moment the initiation takes place, now the formal process begins, which we see in the red. So, the adjudicating authority will pass an order and will appoint the resolution professional. So, the insolvency professional who was selected and who did the reporting and collection of other documents in the second phase will most probably become the resolution professional, will be appointed resolution professional by the adjudicating authority. And then things happen in very quick succession. Within 2 days, the preliminary information memorandum list of claims will have to be handed over to the resolution professional. So mind you, the claims and the information memorandum that is being asked for here in within 2 days have already been prepared in the first phase itself. So we really, it's just a formal handing over ceremony more than actual preparation. The preparation should have already been done in the first phase itself. Then within 3 days, the resolution professional will appoint valuers. So now, as we see, as I had said, that we must look for valuation and forensic audit in first phase. Now, this is just to make sure that your base plan is based upon this valuation. And who knows, we just may not have to go through the second or the third phase. In case everything is good, we could ask for a restructuring from the banks, or from one-time settlement from the banks in the first phase itself. And that is why, assuming that the asset valuation was done by one valuer in the first phase, now in this third phase, the resolution professional will appoint two valuers within 3 days. Then there is a constitution of COC. The resolution professional has to ensure. Then objections by the creditors with supporting documents. So at this time, the resolution professional would also have asked for claims. Yeah, and the claims that the resolution professional would have received, the claimants in the information memorandum or as a separate list, the resolution professional would have reached out to the claimants, and the claimants by the 9th day would revert back to the resolution professional with their objections and other supporting documents. So by the 15th, we look at final information memorandum, which will be prepared by the resolution professional and submitted to the COC. Then in the third phase, by the 21st day, we're looking at invitation for submission of resolution plan. So you see, things are happening very quickly in the first month of the third phase itself. And before the end, by the 21st day, we are already calling for resolution plans. Then by the time the resolution plans come in, the process of opinionating on the transaction audit is another very critical thing, which should, because we have already ensured here in the first phase that the forensic audit was already done. This is, you could just hand over the report, and he could evaluate based upon that report, or maybe ask for another forensic auditor to double check upon the report which is already there. And so the resolution professional will decide in case there are any transactions which could fall under the PUFE transactions. Then by the 36th day, we would have received resolution plans, because it's the last day for receiving resolution plans from general public. In the meantime, the RP, in case there is an opinion, he would have selected a forensic auditor who would have made determination upon the avoidance transaction. And then before the end of the second month, in case there are transactions which were found in the audit, then the RP will make an application to the AA, bringing it to their notice the specific transactions which are which as per law fall under the PUFE transactions. Then the entire next month is spent on ensuring that the resolution plans that we have received here, it's almost close to 1.5 months, but this entire month is to make sure the plans are in order, that the resolution applicants are all 29A eligible. There's a whole lot of documents, paperwork that has to be done by the resolution professional, and also Swiss challenge has to be conducted. So this entire month, the third month of the third phase, is spent on in this manner, which is essentially ensuring the resolution plan and finalization of the resolution plan. Now by the 30th, having done so, we need to submit the resolution plan this entire month later, that the final resolution plan is submitted to the adjudicating authority. And this entire month, the last month of the third phase, is given 30 days, is given to the adjudicating authority to adjudicate upon whether the pre-pack process is successful, whether the plan received is in order. So the adjudicating authority has 30 days. So essentially when we say pre-pack, we talk about 90 days plus 30 days. So it's really these 3 months here in the third phase. These are the 90 days we're talking about, and this is the 30 days we're talking about. Now we really don't discuss about the first phase, which is the informal phase, or rather this is informal phase 1, and this is also sort of an informal phase 2, and only this is the formal phase. So broadly speaking, this is how the scheme would run. Now we can bring this full 1 year process down to 9 months, meaning essentially 3 months in phase 1, 3 months in phase 2, another 3 months in phase 3. Well, you have to have 4 months in phase 3 anyway, because this is given as per law. But we could very well save a lot of time here in case we could. So this is how the calendar would run for the whole pre-pack process. Now, if we look at the timeline, if we look at timelines, let's go over the timelines that we saw in the calendar section, and quickly run over the timelines again. So in the corporate data, let's assume it's phase 0, which means T0. So T0 plus 0 is initiation. This is when you are actually going to start the discussion on pros and cons of the process. Then, having discussed, so we'd like to communicate within 7 days. We'd like to communicate the pros and cons to the other members and the other owners, promoters of the MSME. It is always advisable to go in for a voting at this stage. We actually call upon the voters and members to decide, so that everybody is on board, and that there are no hiccups further down the lane. Then we're going to check on eligibility of MSME, whether the MSME is eligible to initiate, and whether the MSME is eligible as a resolution applicant, because what is the objective? That we start the process and we get back the company. So this is to make sure that you are eligible to start. This is to make sure that you have 29A eligibility, and that the company is would come back to you. We have a preliminary discussion with the financial creditors also at this stage. So essentially we've spoken to everybody, we've taken the voting, we've checked eligibility, we've had a discussion with the financial creditors. Everybody's on board. And now we can actually start spending money. Because there's hardly any cost at this stage, or communication, or voting, or eligibility, or discussion. This is all just discussion and general discussion. But once everybody's on board, because at this stage we will have to start spending money on forensic audit, asset valuation, preparation of information memorandum, preparation of base resolution plan, even preparation for Form 1, because there are tons of annexures that we will see, in Form 1. So this is where your first round of money will be start to, you'll have to spend. And before you spend money, you make sure everybody's on board. Now, assuming everything is clean, we go to the phase 2, which is to be for with the financial creditors and the information insolvency professional. Now, this, let us assume, is T1. So T1 starts with that you will hand over the declaration and special resolution, which you would have gotten it from here during the voting, and everybody is on board. So this is easy because we've already gone through it. And we hand over the declaration and a formal intent of starting the process. And so all these preliminary base resolution plan, declaration, etc. are all required to be shown to the financial creditors. The financial creditors will approve for filing of application, and they will also approve for appointment of resolution professional. So they will say, yes, we are okay with it, you can start filing, we are okay with it. So this is also a formal approval the financial creditors will give in writing. Now, the fact that everybody is formally on board and all paperwork is ready, we will get the insolvency professional into the picture. Now, insolvency professional will be appointed, and certain documents will be exchanged. The resolution insolvency professional will give his will accept the assignment, fees, etc. will be decided upon. And assuming the IP takes over, then within 5 days he has to prepare reports, because he has to now look into all these declarations and this thing. So he has his own checklist to make sure that everything is in place. And he has to file a report that, yes, I've looked at all the paperwork, all the checklists are in order. And by the 75th day, in this phase itself, that we're going to have the resolution professional to prepare his report. Then, in case required, the authorized representative has to be chosen. There has to be 3 consenting insolvency professionals, and there has to be a selection, a voting process, typically from home buyers, or generally we have seen authorized representatives coming in only in the case of home buyers. So from the class of creditors, will have to communicate their choice of the authorized representative. So a process where we reach out to a class of creditors, say example home buyers, and they'll have to get back as to which authorized representative do they choose. And then within the 90th day, the corporate debtor has to now file the application for initiation. So this is where the Form 1 that we had prepared here will come into play at this stage. And this is tentative. It could very well should have been 14 days, but we can have the assuming the authorized adjudicating authority initiates the process, and we obviously get an order along with appointment of a resolution professional. Formally, he'll be coming in as a resolution professional, and the formal process of the pre-pack will take place in phase 2, because if this is phase 0, then it's phase 2. If it's phase 1, then it could be phase 3. Now, in the last phase, we have the adjudicating authority passing order and appointing resolution professional. Then within 2 days, there is public announcement. Within 2 days, he has to do these 4 things. The resolution professional will be doing 4 things within 2 days. He will accept the list of claims and a preliminary information memorandum, as also the base resolution plan, as also the list of creditors and claims. So immediately he will get the preliminary information memorandum, base resolution plan, list of creditors, and then he will immediately, the resolution professional will start contacting the creditors, and the creditors will have to Okay, so this is on the third. The resolution professional will also provide list of creditors with each class of uh, resolution applicant. So there's something I'll have to double check on this line. Then within 3 days, as we see here, that so within 2 days he will take this. Within one more day he will appoint the valuer. Within 7 days he will constitute a committee of creditors. Objections, by this time the objections by the creditors will be received by him. Creditors meaning at this stage the list. When he receives the list, he will obviously approach the creditors. Okay, this is the amount that I have received, please verify. And in case there are objections, then within 9 days they'll have to get back with the objections along with evidence. 14 days list of first meeting. In the first meeting of creditors, committee of creditors, the information memorandum would also have been finalized by him, should have been finalized by him at this stage. Then within the 21 days itself, that there has to be a call whether the resolution plans have to be invited from general public. Now, in case there are operational creditors who have not been fully compensated, it is mandated that resolution plans will be called from the general public. And otherwise, if the financial creditors choose to take a haircut without impairing the operational creditors, then there may not be any requirement to go in for inviting resolution plans. But this is, in my opinion, it is almost likely, highly unlikely that invitations will not be called upon. Then by 36th day, the general public will have time within 15 days to submit the resolution plans. So the time with them to prepare a resolution plan, submit within 50 days, very tight. And although we have created a system, standardized planning system, which will ensure that plans can be created, will be prepared within matter of days. And not only the plans will be created within days, that the plans will become comparable and scoreable. And this is where technology comes in, and we will go through that in a separate video. Then resolution professional to form an opinion on transaction audit. He has to determine if the transaction audit is there, and he has to make an application to the adjudicating authority on the transaction audit. So this is another thing that will be happening on the site. Finally, between T60 and T90 for this entire month, the process of going through resolution plans will happen. The resolution applicants will be verified, and the Swiss challenge process will be conducted. Now, Swiss challenge process is also built into our auction system here. So if I could quickly show this to you, or maybe we could do this at a later stage. Maybe I could show it to you here itself. So in the resolution process, in the auction process, we could choose that whether you wanting to do an asset sale auction, or is it an interim finance auction, or a Swiss challenge auction. So so all these are nothing but auctions. This is called a forward auction. This is called a reverse auction, and this is a Swiss challenge auction. It's called a multivariate, or what's it called, because this auction is not dependent on just one variable, either price or percentage. It is a multi-parameterized auction, so it's a slightly different. But we will go through all these details at another in another video. So for this entire 30 days, we will be going through the process of selection of resolution plan. And on the 90th day, before the 90th day, we have to submit a resolution plan to adjudicating authority. Now, for the next 30 days, between 90 and 127, the adjudicating authority will determine whether will terminate the PPIRP process, either with approval or with the rejection of the resolution plan. And in case the resolution plan is approved, within next 7 days, we intimate to every claimant as to what happened to the resolution plan, whether it was approved or rejected. And then, well, another phase, which is called the monitoring phase, the implementation of the resolution plan phase, will begin from here on. And I have not shown it here, but I think it would be a good idea to show it here. So I'll have it added. So broadly, these are the timelines for the pre-pack process. Now, we have gone through the calendars, we've gone through the timelines. We can go through the process cost. Now, let me tell you what the process cost is, because a lot of people have asked us to how much it's going to cost. As I said, the cost is in phase 1, phase 2, and phase 3. Okay, well, I haven't put in the numbers here, but so for example, let's go through this as an example, and I'll have to get back to you with some realistic numbers. But for discussions to pros and cons of PPIRP, it really costs us nothing because we are just discussing at home. So this is not. Communication of the pros and cons of PPIRP to the other owners and stakeholders is also something that doesn't cost us anything. Voting or by directors and members of MSME. So this could really cost you anywhere between 5,000 rupees or maybe nothing in case you have an informal process. But let us say there is a proper e-voting and we have a system and it's going to cost us 5,000 rupees. Then we have to check for eligibility of MSME as an initiator or MSME as a resolution applicant. So essentially at this stage, we need to go to some advisor to ensure that we are in place, as well as the 29A is compliant. The resolution applicant is 29A compliant, and 29A really depends upon how many applicants are there. So assuming that there are two applicants who are jointly putting in their application for taking over being a resolution applicant, and every 29A costs us say 10,000 rupees. So two applicants eligibility might say cost us 20,000 rupees. These are just tentative figures. I'm just giving you an idea as to what's going to happen. MSME as a PPIRP initiator, I presume that you will be going to an insolvency professional or even your chartered accountant or your lawyer, and he might also charge somewhere around 25,000 rupees minimum to make sure that we are all in compliance. Discussions with financial creditors is just a discussion. It should not cost you anything. And forensic audit and asset valuation. So I'm insisting that we need to do this in this phase 0 itself. And so this market is really open. We have really no idea because it all depends upon whether your MSME is micro, medium, small, or the forensic auditor are one of the big companies or a chartered accountant next doors. It really depends. So assuming that you're a very small micro company and a forensic audit for past 2 years, let us assume that a chartered accountant next door charges you say another 15,000 rupees for this. For asset valuation, assuming that again, for a micro, there are hardly any assets, and however, it will still cost you, say, 10,000 rupees for valuation. Then for preliminary information memorandum is something that you have to do a lot of collection. We'll go through all the checklist of what a preliminary information memorandum looks like. I could give you an idea if we were to look at checklists and if we were to look at preliminary information memorandum. Then this is, you need to have your list of assets and liabilities, your annual financial statements, your provisional financial statement, list of creditors, debts from related parties, guarantors who have been there, your partnership holding, litigation and investigation, worker and employees list and their liabilities, any other information. So this is typically what an information memorandum looks like. And but there is no reason to believe that this is something that you cannot collect. This information you cannot collect on your own. And since you already have running, it's already a sunk cost that you're already undergoing, so this will not cost you any additional money. Base resolution plan. Now this is where things can get tricky, because if you were to look at base resolution plan, so it has, the resolution plan has two things. One is the contents, another is the mandatory contents. So if you look at contents in a similar manner, we see that you have to decide, whether you're going to transfer the assets to another person, whether you're going to sell some assets, how are you going to restructure your company, how are you going to, acquisition of share by any other person, how are you going to distribute your shares, whether you're going to cancel or delist shares, how you're going to satisfy or modify any security interest that you have, curing, waiving or breach, reduction of amount payable, what kind of haircuts are you looking at, extensions of maturity date, whether you want extension of your loans or reduction of any interest, amendment to your constitutional document, issuance of securities, so etc. So there are, making a resolution plan can get very tricky. It is not a process that you would be able to do it yourself. What kind of changes in portfolio are you looking at? If you're going to add some technology, what kind of approvals are you looking for from the central state government? So these are some very basic requirements of a resolution plan. However, not only do you require some basic information resolution plan, you will have to also have some mandatory contents as per law. Meaning, if I were to bring this back up, that you have to give in your affidavit, your statement of failure, what happens in case you fail to implement whether you have failed to implement a resolution plan, and what happened in that case, undertaking that any false information will lead to ineligibility, terms of plan, management control during the implementation plan, and also monitoring and implementation after the resolution plan is approved, adequate means of supervision, implementation schedule of the resolution plan, addressal of cause of default, so whether you have identified the cause of default and how have you addressed it, feasibility and viability, provisions of effective implementation, whether you have given enough provisions to effectively implement the plan, provisions for approval, so what kind of approvals are you looking from the state or the central government, and what timelines are you looking at, and whether the resolution, you as a resolution applicant are capable of implementing the plan, how have you dealt with the interest of various stakeholders, whether you have ensured that the operational creditors are being paid in priority over financial creditors, or dissenting financial creditors are being paid in priority over the financial creditors. So as I said, there are making a resolution plan can get very tricky. You just might have to go to an insolvency professional, somebody who knows how to make resolution plan, and he could very well charge you close to 1,50,000, or, well, it really depends upon, as I said, upon what the company size is, what kind of plan is, and it could range. It could start from 50,000 rupees in case you are a really a small this thing. But however, the requirements of the laws are such that a professional may not be able to make a plan for anything less than this. So let us again, for the sake of argument, assume some. And preparation of Form A. Now this is also very tricky. Form A, if we were to look at, okay, it must be in forms. Under forms, we look at Form A, application. So under forms, so not only is this, okay, this is fine, this is a matter of information, but where the problem comes is when you have to look at this. In case of financial debt, you have to get the record from the information utility. In case of operational debt, you have to collect copies of invoice default, approval of creditors, written statement of proposal, resolution declaration by the majority of the directors, copy of special resolution, approval of creditors, a report of the insolvency professional, declaration regarding the existence of any transaction, affidavit stating that the corporate debt is eligible under 29A, copy of relevant books, copy of audited financial statements, statement of affairs. Statement of affairs would then further have list of assets and liabilities. In case of property, wholly or partly secured, how the security was created over the property. Names and results of financial creditors and operation creditors, debts, guarantees, names, relevant extract of constitutional document of employment agreement, etc. So the point being that for Form A, even at this stage itself, you might have to start approaching your an advocate to look at it and make sure everything is in order. Not that things are, we will obviously not have all these things, but whatever things that we can produce at this stage, we should have it. And or the same person who's making your base resolution plan should also be able to look at the Form A requirements, and assuming that is the same person and he's able to do it in the same fees, this will also not cost you anything. So if you look at it, anything below 1,25,000 onwards, I mean, this is the barest of minimum that you could be looking at it, and it could really go up to 5 lakhs, for example, depending upon who the asset, forensic audit, asset valuation, information on the base resolution plan, Form A. So anyway, this is tentative costing of what phase 0 would be. Now we have looked at costing sheet in phase 0. We could now go to costing sheet of phase 1. Well, frankly, I thought that it will take much less time, but it seems that our discussion is going way past my initially decided time. But anyway, let's go through it. I will not fill this form yet, but we'll go over it. So declaration and special resolution will be given by the corporate debtor, shouldn't cost you anything. Approval by financial creditors for filing application shouldn't cost you anything. Approval by financial creditors for appointment of resolution shouldn't cost you anything. But the appointment of resolution process of professional onwards is going to be the tricky part, because this is where the insolvency professional will start asking for his fees, because he is now supposed to start making his reports and documents. So the insolvency professional here, this is where he'll start charging anywhere from 50,000 rupees a month upwards. So you have to cater, and at this stage I must bring it to your notice that assuming that the insolvency professional becomes the resolution professional in the next phase, and that this phase plus the next phase together take 8 months. So 8 into, assuming that he's asking for 50,000 rupees a month, then you need to have put in 4 lakh rupees for the fees of resolution professional in the bank right away, before the insolvency professional begins to work. So you should be prepared to have a bank to put in anywhere between 8 to 10 lakh rupees minimum in the bank, which will be the charge of that bank account will be given to the resolution professional, because for him to start the process, which will include valuers, forensic auditors, and so many other things. So at this stage, if nothing else, I think we should very well put in that you need to put in at least 10 lakh rupees here in the bank account. So we might as well put in some figures here and see where this goes. Yeah, okay. The RP will take 5 days to prepare reports. Fine, he has already been paid for. Selection of AR from 3 consenting IPs. So in case there are home buyers, we need an authorized representative. An authorized representative will charge, say, almost anywhere between 10 to 25,000 rupees per meeting, assuming there are 3 or 4 meetings. So we're looking at 25, 30, yeah, 30 to 50,000 rupees for the authorized representative. Now, assuming that we are looking at a real estate company, we could very well assume, well, some money here, but that money, whatever he will be charging, will be spent from this 10 lakh rupees that you have given. And right now we can very safely assume class of creditors will communicate to the authorized representative, application for initiation with the adjudicating authority. Yeah, initiation by the adjudicating authority. Okay, well, of course there's an application fees here, but we are again assuming that this 10 lakh rupees that you put in here uh, will be able to spend all this, will be able to cover for all these things. And adjudicating authority initiate and appoint the RP. So we should be good here. So now what may happen that the adjudicating authority may not appoint the IP, may not allow the application to go further, may not accept the pre-pack to start, in which case you don't have to put in 10 lakhs here, because we are really looking at only these 3 months fees over here or 4-month fees here. So far as the insolvency professional is concerned, assuming it's 50,000 rupees, so we need to put in 2 lakh rupees for him, and maybe another 50,000 to 1 lakh rupees for other miscellaneous purposes. So we are not really looking at more than 2, maybe 3 lakh rupees here, to be put in the bank account. But assuming that the adjudicating authority does accept the application, the pre-pack application, then immediately you will have to put in another 3 lakhs or maybe whatever more in the bank. You'll have to put in more money in the bank so that the RP can continue his process in phase 3. So overall we are looking at spending, so as we saw in phase 2, we saw that we spend about 1.5 lakh rupees here. Then in phase 1 we're looking at minimum, so let's assume that here we spend 2 lakhs, here we're spending 3 lakhs, so about 5 lakh rupees you would have spent by this time. Now we could go in for the final phase, wherein what happens in the formal phase. So AA passes an order for initiation, appoints the RP. The moment this happens, as I said, in the bank account itself, you will have to put in more money. So let us say you have to put in money. Let's assume the overall process cost is, so let's say you put in 5 lakh rupees. You have to top up the bank account at this stage. So the moment he does that, you have to put in 5 lakh rupees in the bank. Now, public announcement is not taking place in the newspaper, so it's not going to cost us anything. Submissions of list of claims and preliminary information you've already made, so you're just handing him over. Submission of base resolution plan, again you've already made, you're just handing him over. List RP to confirm list of creditors and claimants. Yeah, so the list will also be handed over to him. Again, you've already spent money, so you don't have to. This I'm not sure. Provide list of creditors with each class of creditor. Okay, so this also is just providing a list of creditors. It shouldn't cost us anything. And appointment of valuers. So now here we have already given him money. We just have to spend money, but assuming that the valuers are, so there are 2 valuers here, and there are 2 valuers here. Now, really valuers, the way the law works is that there are 3 classes of assets. You're having land and building, plant and machinery, financial assets, and 2 valuers are required for every class of asset. So assuming you have at least land and building, plant and machinery, and you may well, you will have some financial assets. So you will have to have six valuers coming here. In which case, in our previous case, over here, I think I made a mistake. In phase one, when we looked at asset valuation, so we are going to look at three valuers here. So assuming that they are going to charge us, 10,000 each, we're going to charge, 30,000. And forensic audit, it's 15,000 rupees a year. For 2 years, he will obviously charge no less than 30 here as well. So as I said, that this is tentatively going to cost you no less than 2 lakh rupees. So no matter what you do, you could very easily, because of communication, voting, or preliminary information memorandum, you just might have to spend another. So we're just going to throw in some more figures here, just to make sure that we have some reasonable looking preparation of information memorandum. Let's assume that you go to a lawyer and you give him some money. So we see that this phase is not going to cost you less than 2 lakh rupees. This phase is going to you're going to put in 3 lakh rupees, and we're going to more or less spend this entire money here. So by the time you reach your phase 3, you would already have spent a minimum of 5 lakh rupees. So that's what I wanted to say here. Now over here, so we can top up later, but let's say this is not going to cost you AA to pass order for appointment of resolution professional. Okay. Yeah, I haven't broken this down, but here is going to be a lawyer here who will be fighting this case out, who will be applying for this thing, and let us, for the sake of argument, give 50,000 here. File application for initiation, class of creditors. So the AR comes in here. So AR will obviously end up getting something like I don't know, maybe 50,000 rupees over here, and the insolvency professional will charge a minimum of say 2 lakh rupees here. So this will again be 3 lakh only, except that there will be some bit of bifurcation. So we have spent 2 lakhs in the first phase, 3 lakhs in the second phase. Now let's go to the formal phase and let's see how much money we end up spending here. So the order the order to be passed by the adjudicating authority, we would have already paid for. Public announcement doesn't need to be made. Submission we have already done. Base resolution plan, confirmation, list of creditors, appointment of valuers. Now there are 6 valuers that come in here. Now assuming they still charge you 10,000 bucks each, and there are 6 valuers, 1 for each class, 2 for each class of assets. Obviously this is much lower. It's not the see in the first phase I charged much less because I assumed that it will be a sort of informal, but this is a more elaborate report that the valuers have to give. So I don't think they are going to charge for anything less than 20,000 rupees. So we could very easily be looking at 1,20,000 here. I'm talking about minimum micro industries here, right? And this could anyway. Constitution of COC is not going to cost you anything, and objection by creditors with supporting documents is solved. The job of the resolution professional we've already paid for. Well, in which case the appointment of RP has been made here, so the money to the RP has to be given. So we are looking at 50 into 4, assuming he agrees with for 50,000 rupees, and there is a process for 4 months. Now this is a more intensive process. I don't think he an IP would agree for 50,000 rupees. He would definitely look for more, and we could very easily be looking at 1 lakh rupees a month for the resolution professional for these 4 months. So we're looking at something like 4 lakh rupees here. So we're looking at 4 lakh here, 120 here. Constitution of 0, objection by creditors is we already done. First meeting of COC, and final. Okay, so meetings of COC, assuming they're all online, and we don't want to spend any money here. Final IM will be looked into and submitted to the COC. Again, it doesn't cost us anything. For invitation for submission of resolution plan. Now this invitation, again, as I said, you don't have to, we are not going to make any newspaper advertisement. We're just going to put it on the website of the IBBI, or maybe you could put in, like for example, in our case, what happens is, if I were to show you something like this, okay, let's say this. So this becomes a website in itself. So all these documents that you put on the website are put in here. So you don't really need a separate website, because the server that this technology that we offer is also like a website. So not only do you have access to all these site information, you also have access to all these digital worksheets. But the way this works is, it works as your website, it works as your data room, it works as your voting, it works as your auction, and there are a whole list of services that you could use it here, all the way from phase 1 to phase 3. So phase 1, we could initiate this whole system for you, and then you can just hand it over to the insolvency professional, who can then hand it over to the resolution professional. All you really have to do is make them users of the section here, and you could give them permissions to do whatever, whether they have admin permission, or they have staff permission, or they have user permissions. I haven't added the cost of technology here, which I think I should right in the beginning itself, but we will discuss that. We will discuss that subsequently. Constitution of CS, okay, we've gone. Invitation is fine. Last day for submission, again, it doesn't cost us anything. And the resolution plan preparation will be done by the resolution applicants themselves. Now, resolution applicants, the way they can prepare a plan. So what you see here is a digital worksheet. Now, this worksheet is a worksheet which you don't need anything else other than this worksheet. This worksheet gives you the forms, it gives you the law, it gives you explanations, it gives you areas where you can start building your information memorandum or your resolution plan. So all you really have to do is that for every section that we see here, you just keep adding comments, and the system will automatically create a report from your comments, which will automatically become your information memorandum or a resolution plan. Now, a similar watered down version of this digital report will be given to all the resolution applicants, who will then in the similar fashion add their comments to whatever the aspects of the plans. So we are trying to standardize the plan here. Everybody just has to give in their comments, and then we get a resolution plan based upon everybody's different comments, which then the system can compare and score. Now, I could show you a demo of that, except that it's going to become very long. Let's complete this first, and let's see what we can cover, and if we really want to cover, in this video itself. So, resolution plan to form an opinion on transaction audit. So this is where the transaction auditor comes into play. Now, transaction auditor again depends upon who the people are. Let us assume that they charge 1 lakh rupees to conduct a transaction audit, and then the determination of the transaction audit doesn't cost. We've already paid the resolution professional. He has to make an application, and there may be then multiple applications going back and forth. So let us say that we for 1 or 2 applications, and for a couple of dates, we give some tentative amount for the lawyer. Although, as I said, that this could really range from 50,000 rupees to 5 lakhs. So it all depends upon from case to case, but I'm just giving you a tentative idea. Submission of resolution plan for the adjudicating authority is the same thing. We've already paid the lawyer, let us assume, and we could pay him a little more here. Anyway, termination of an approval or a rejection of the plan, Again, it doesn't cost us anything, and intimation is already something that we have. Okay, so we intimate all the stakeholders as to the outcome of the process. So we're looking at spending, as you said, we're looking at spending anywhere between 10 to 15 lakh rupees at this stage. Yep. So we're looking at anywhere between 10 to 15 lakh rupees. So let's say this is 11 lakh here, and as I showed you in the previous phase, phase one cost us say minimum of 2 lakhs, phase 2 costed us a minimum of 3 lakhs, and phase 3 will cost us anywhere between 15 lakhs. So we're looking at 2 plus 3 plus 15, minimum of 20 lakh, 15 to 20 lakh rupees that this entire process would be for a small micro plant. And the RP could charge up to 2 lakh rupees a month. The other professionals could come in at whatever this thing, but I have given you a tentative idea as to what the costing would be. So let's recap before we close the discussion for today. We wanted to go through various calendars. So what we saw is that so this is the tentative calendar that we're looking at, and each section has so you could actually go in here and you could fill in this. You could start so the reporting will be generated by the system by this digital sheet. The information memorandum will be automatically generated by the system. The resolution plan will be generated. If everybody fills in the same digital sheet in a similar manner, then we could very well have a plan comparison become very easy. If I were to give you an idea of what the resolution plan looks like, so we look at the scoring and we look at a score sheet. So this score sheet is to be depending upon what variables do we want the scoring based on. We could we could score a person, and then based upon the set formula we will find whatever score there is to it, and this could be the formula as given in the regulation. And of course these are too many. These are about 15-16 variables. You could just select 5-6 variables depending upon what you want to plan upon. And so this scoring is being done on this sheet. Now this scoring can be manual, can be automated, and if everybody fills in the sheet in a similar manner, then the system will score them and present you a matrix. And from there on you could go in for auction, as I showed you earlier, that you could then put in through a Swiss challenge process. And I will show you what all these three things are in the next video. So I think I should stop here because it's really becoming very long, and I hope I hope you like it, and I'll see you in the next video. Thank you.